Hey, everybody. Welcome to Wednesday, True Crime Wednesday. 2 nights in a row we've been together, and I'm so glad that you're joining us. Sorry about that. I'm trying to adjust my camera and get everything in frame here. I had the best day today. So I have been super lucky. Now, I know there is somebody in chat who always complains that I vamp too much at the beginning and that I should get to it. So, but I do this so that people who are just joining us can hop on and we can all sort of get into the groove. So, I just want to say I had the best day today. I have been super fortunate that I have met some amazing people from our true crime community who live in my local area, in the Boyce area. And so I had the pleasure of meeting Jane today. There we are. We had lunch together and I had an absolute blast. Yesterday, I had lunch with Cheryl and we had a blast too. In fact, we both laughed so hard that she was threatening me with bodily harm because she was sure she'd pulled a muscle. So I'm just super excited about the fact that I have met all of these amazing people. It has made the move to Boise so much easier for me. So that is a great segue into the fact that we're going to have a pizza party and get together. I know somebody in chat said this shouldn't be a party because we're coming up on a murder trial. I realize that it's a solemn reason to get together. However, that doesn't mean that we can't find a little joy in the silver lining that is the community that we've built around this case. I just today got an email from another member of our community who made a really sweet and generous offer to Kay and Larry Woodcock, who I just realized I still have my earbuds in. I was listening to stuff at dinner before dinner. She just made a really generous offer to Kay and Larry, which I have passed on to them. And our community is just amazing. This is the silver lining in this awful case, is that we have the most amazing group of people in our community, and they really have taken the victims and their families to their hearts. And so I just appreciate all of you. I am hoping that we're going to have a couple special guests. I have invited Gigi and Scott Reich both to join us because they're going to be in town for the trial. So I'm hoping that you'll get the opportunity to meet them as well. So Victoria, Gail, Julie, and Jennifer. I expect to see you at the pizza parlor because we've had lunch and gotten together and had a great time. Diane, that includes you. So let's all get together and just spend a little time together, get to know one another, and have a little bit of fun before we start this long road. Tonight, I've got several things that I wanted to talk about. Just little news tidbits, and then we'll get to your questions. There's a few little bits of news to talk about. So I'm going to start with the Kohberger case. As you all know, Brian Kohberger was arrested on murder charges in the deaths of the 4 college students at University of Idaho. And he remains in custody. His preliminary hearing is coming up in June. The court has been kind of slowly releasing some of the search warrants and the search warrant returns as time has gone on and those search warrants have been completed. And so we've begun to get a little bit of insight into the investigation and to what was going on in that investigation, which is really interesting. The other little tidbit, which is interesting, is that the state of Idaho has now approved $1 million for the Kohberger investigation. So we know that the Valo investigation, they have already spent $3.6 million, and the case hasn't even gone to trial yet. So I'm sure that that first $1 million is going to be a drop in the bucket as that case goes on. I want to turn just for a couple of minutes to the Murdaugh case and Stephen Smith. I saw a really interesting interview with Law and Crime and Eric Bland, who is the attorney both for the Satterfield family and for the Stephen Smith family. For those of you who aren't familiar, Stephen Smith was a young contemporary of Buster Murdaugh's. They went to high school together. He was a young gay man living in the South, probably not the most forgiving place. He was a nursing student, and he died very mysteriously. His body was found in the middle of the road, and his death was initially ruled a hit and run, even though there was no evidence to support the fact that he had been hit and run. It appeared actually that he had been murdered someplace else and his body had been placed in the road. So just recently, Eric Bland said that he had had a conversation with SLED, the South Carolina Law Enforcement Division, which is their state law enforcement agency. And they have now designated, or they now consider his death a homicide, and that his death was caused by someone. So it is a murder, and there's an investigation going on. There have been rumors for a very long time that Buster Murdaugh was somehow involved. What we do know is that Randy Murdaugh and Alec Murdaugh were on the scene and were, to some extent, involved, Randy Murdaugh offering to represent Sandy Smith at one point. There is some suspicious involvement by the Murdaugh family because they kind of had their thumb in everything. If you recall, Paul and his girlfriend Paul was drunk and driving too fast and turned his truck over with his girlfriend with him. And before the police could arrive, Alec and Maggie arrived and unloaded all the guns and all the alcohol out of the truck and whisked them away so the police wouldn't find them. So there's a long history of the Murdaugh family bailing out their kids. So we don't know for sure whether we don't know anything about Buster's involvement, and he has categorically denied that he was involved and put a plea out for the press to leave him alone. Now, Stephen Smith's mother, Sandy, started a GoFundMe account to have Stephen's body exhumed 7 years later to have a new autopsy done. She believes that the autopsy wasn't accurate or complete, and that a new autopsy would help identify his actual cause of death and identify, perhaps shed some light on what happened to him. So they set up a GoFundMe account to raise $15,000 to have his body exhumed and do the independent autopsy. They raised $80,000. So thank you if you all were at all involved in that GoFundMe account. That is super exciting. And Eric Bland has announced that they will continue to use that money solely to pay experts and to finance their own investigation into Stephen's death. So there's been in a little bit changing gears here. There has been a lot of consternation about a YouTube creator who did a Freedom of Information Act request for all of Alec Murdaugh's jail calls. The jail inadvertently included a telephone call during the trial between Alec and Jim Griffin, his attorney. Any communication between an inmate and their attorney is attorney-client privilege material and should not have been released. The release was inadvertent. When someone pointed it out to the Colleton County Jail, they immediately contacted the creator and asked them to take it down. To this point, my understanding is the creator has decided not to take it down, has sort of cloaked themselves in the Freedom of Information Act and the First Amendment, and said that they had a right to post that information. I've also seen the tweets from Jim Griffin that he is very angry about this. And Jim Griffin is a very wealthy, powerful man in South Carolina. So it's really unfortunate. Had anybody asked me, I would have advised them to do something a little bit different, but that's where we are. I don't usually comment on other creators. I like to lift people up, and I like to point out creators that are doing really good work, and I don't comment negatively on other creators. So, but I did get a lot of questions about this in the last few days. So I wanted to let you know that it happened. It's very unfortunate. I feel bad for them because we all make mistakes. So I hope they can push through that. Next, we're going to talk about why is the Supreme Court talking about poop? And here is the reason. This company put out a product called Bad Spaniels. And it's very clear that it is modeled sort of a parody of Jack Daniel's whiskey. The funny part about it is that the bottle says something along the lines of the old number 2 for when the old number 2 when your dog deposits it on your carpet, basically. And Jack Daniels came back and said the old number 2 on your Tennessee carpet was what the toy said. And of course, Jack Daniels is the old number 7. And the whiskey maker is taking them on because they feel that it's a misuse of their trademark. And what they said was that Jack Daniels loves dogs and appreciates a good joke as much as anyone, but Jack Daniels likes its customers even more and doesn't want them confused or associating its fine whiskey with dog poop. So the U.S. Supreme Court is taking this up. I'm sure that the amicus briefs, there've got to be a few that are tongue-in-cheek and that are absolutely hysterical. But it is an interesting issue because it's the intersection, and this isn't a criminal case, but I thought it was an interesting gee whiz. It is the intersection of trademark legislation and the First Amendment. So on one hand, we have federal legislation that protects corporate trademarks. And then on the other hand, we have the issue of what the law really terms parody or comic comment and satirical kind of comment. So on one hand, we have the First Amendment protections for that kind of speech. And on the other hand, we have trademark law. So it is sort of interesting. I hope the U.S. Supreme Court is having some fun with it as well, with a little bit of tongue-in-cheek, because they deal with an awful lot of really weighty and boring subjects. So it kind of has been all over, lots of poop emojis, like this one, talking about the Supreme Court and why it is that they are talking about poop. There is another issue that has come up recently. A lot of people have been asking me about this in conjunction with Chad and Lori's case, and that is that we've talked at length about the fact that states who still have the death penalty and impose it by the use of drugs and have been having a lot of trouble getting the chemicals that they need in order to perform those executions, because a lot of the manufacturers are refusing to sell to states if it is the it is the purpose of using. I'm sorry, I just got distracted by chat. It is the purpose of the manufacturers are not selling to states if they know that the purpose of the drugs is to perform injection type executions. So it is getting more and more difficult for them to get these chemicals. The state of Idaho has responded to that shortage by introducing a bill in the state legislature that would bring back the firing squad. Now, Idaho has an interesting history with the firing squad. It was added as an execution option in 1982. Now, y'all may remember that the 80s were a period where there was a lot of pushback on victims' rights and a lot of pushback on more conservative, more jail, more longer sentences, mandatory sentences. Those were all things that came out of the early to mid 80s. And so in response to that, a lot of states did institute more stringent and mandatory sentencing structures, and the state of Idaho even reinstituted the firing squad. Now, no one was ever executed by the firing squad, but it was an alternative. Then in 2009, the legislature removed it and said, we're not going to allow people to have firing squad. So it was never used, and it was taken back off the books. There have only been 4 firing squad executions since 1960. And Mississippi, Oklahoma, South Carolina, and Utah are the only states that currently allow death by firing squad. Probably the best known case is Gary Gilmore, who was executed by firing squad in Utah in 1970. If you have not read this book, it is sort of the seminal true crime book. Norman Mailer was a remarkable writer. It is exhaustively researched. If anything, it's very thick. And if anything, you probably will think, oh my gosh, Norman, why did you have to talk to that gas station attendant who pumped their gas? And I mean, he is very down to the granular level, but it is a fascinating story. Gary Gilmore grew up in Portland, Oregon. His crime was committed in Utah, and he was executed in Utah. His brother, oops, sorry, wrong slide. His brother, Michael Gilmore, also wrote a book about his brother, and it is excellent as well. And I always recommend that if you're going to read Executioner's Song, that you read this one as well. I think that it gives some additional insight that is really valuable. So the firing squad at this point, my goodness, I can sure tell spring's around the corner here. My allergies are acting up. Um, As I say, only 4 people since 1960 in the entire United States have been executed by firing squad, so it is not a popular mode of execution. The Idaho Supreme what has happened so far is that the Idaho House of Representatives has formulated a bill, passed it out of the House, and passed it off to the Senate, and it is currently under review with the Senate. It has not been enacted, not been signed by the governor. We don't know what it might look like, whether it might have an emergency clause so that it would get put into place immediately. We don't know any of those things. So it's a little bit too early to sort of suppose those things. But I do recommend, if you are interested in true crime at all, if you have not read Executioner's Song and then Shot in the Heart, they're really worth your attention. And then the last thing, of course, I want to do is talk a little bit about the Valo case. A sharp-eyed viewer was out in about 2 hours outside of Boise at a gas station in a very remote location and happened to see what appears to be state police and jail personnel with Lori. And it's clear that she was being transported. So I think we can safely assume that she has been moved to Ada County. I think that, oh yeah, so Vine just came through and said that she's in supervised custody. So that indicates there's been a move. So I'm sure that they picked that sort of remote location because they were just sort of getting gas. I'm sure that she had a potty stop, and I'm certain that that she is. It appears she is here in Ada County in advance of the trial, and that everything points to the fact that we are going full steam ahead for a trial. There were quite a few documents that dropped today, and I am going to do my best. I am leaving tomorrow morning to go to LA to do wedding planning, but my daughter is working, so I'm going to have some time while she's working that I'm going to be able to get, I hope I'm going to be able to get our newsletter out. So I'm going to work on that. One of the things that I do want to talk about in the newsletter are the proposed jury instructions. So those were released today. They were filed and released on the portal. And I think it's interesting when a trial is imminent, both sides propose jury instructions. Sometimes every state has a set of uniform jury instructions, and they're created by a committee, usually of lawyers and judges, prosecutors and defense, and they're designed to be a launch point. They're not designed to be the only instructions that can be given to a jury. So both sides usually supplement the uniform jury instructions with maybe amendments to the written jurisdiction jury instruction, and maybe completely separate and new jury instructions. And then they kind of hash it out. They sort of have they'll have a meeting with the judge and the attorneys, and they will hash out the language that will be used in the jury instructions. Included in that was also the proposed verdict forms, which can be very informative because they are designed to be filled out by the jury when they've reached their conclusion. So those things dropped in the portal, and they're really things that we lawyers get in the weeds over, and they're incredibly important, but they're a little esoteric sometimes. So get your ghillie suit on and we'll get in the weeds together in the newsletter. I try and use the newsletter to do sort of deep dives into legal issues. So, if you're not a law geek, sometimes you might be like, I'm going to gloss over that. And I get that but a lot of folks who follow these cases really enjoy learning that piece of it. It helps them to understand things as the trial goes along, to understand the lingo we use and what we call terms of art. And it all helps for everybody to be able to understand what's going on in the courtroom. So I'll be getting into jury instructions and verdict forms and all of those things in the newsletter in more depth. But know that those things dropped on the portal. They're out there. People are circulating them. And what will happen next is the defense proposed theirs, the prosecution proposed theirs, and now we go forward with this sort of reconciliation meeting with the judge to decide exactly what the wording of all these instructions is going to be. So that indicates that we're moving ahead full steam ahead. Proposed jury instructions are some of the last things we do before we start jury selection. We know that jury subpoenas went out. One of our group community has a relative who's on a mission and received a jury summons for March 27th. So probably would have been in the jury pool if he was not off on his mission. So it's a small world. But we also know that at the end of the hearing where the judge decided to take the death penalty off the table and dismiss the death penalty notice, at the end of that hearing, the judge, Rob Wood, asked the judge for an expedited transcript of the hearing. Transcripts sometimes take months, so who knows what an expedited transcript looks like. But I do believe that they are intending to file an interlocutory appeal. Now, for those of you who may not remember, an interlocutory appeal is an appeal that happens during the pendency of the case. Most appeals happen once the case is done, the final judgment is entered, and then there is an appeal to appeals court or the Supreme Court. For felony murder cases, it would go directly to the Supreme Court. When that happens, then the judge reviews what's already happened in the case. What may happen in an interlocutory kind of appeal is the court can say, hang on, we're not going forward because we need to decide this issue. I don't think that is going to happen here. I do not think that that the Supreme Court is going to take this up on an interlocutory basis. They may very well make a different decision on the after when the case is over. Prosecutors have limited ability to file appeals, but filing for an interlocutory appeal may preserve that for when the trial is over. So the interlocutory, I know that Rob Wood has had this conversation with Kay and Larry because they did an interview where they were talking about the fact that they are hopeful that there is going to be an interlocutory appeal. And Larry is heartbroken and very disappointed that the death penalty is off the table. And I completely understand that. I have to always look at the case and say, I am not sure how I would feel if this were my family member. I don't know how I would feel. And I could never imagine what it's like to be in their shoes. So I don't really, I mean, I feel for Larry and Kay. My heart breaks for them. I know that they would like to have this over, but I also understand that they feel this is an issue of justice for the kids. So I honestly don't know whether I think it's unlikely at this point that there will be enough time for them to file an interlocutory appeal and for the court to make any sort of a decision on going forward with the trial. The wheels of appellate justice turn incredibly slow. You think this case has been slow getting to trial. This is a walk in the park compared to an appeal. So it is, I think it's unlikely that they're going to be able to get this interlocutory appeal up. Now, appellate courts do give priority to interlocutory appeals, but I don't know whether they're going to be able to do it or not. I hope that it is not going to delay the trial. The appellate court has the option to say, we will not review this. What makes me a little nervous is the fact that there is no precedent in Idaho. We talked a little bit about this last night. When the judge went through and made his decision, he outlined the reasoning that he used in order to get to that decision. He clearly has the right, the authority under the statute to make the ruling. And there is a basis for him to impose a penalty of some kind on the prosecution for their discovery violations. So, but there is not precedent in Idaho for dismissing the death penalty as a penalty for not providing discovery. So the judge, in any time a judge is looking for legal authority to do what they do, the first thing they're going to do is look at the state statute, what the legislature decided about this issue, and that is the binding law. After that, they're going to look at the local Idaho Supreme Court, how the Idaho Supreme Court might have interpreted the legislature's intent or the law that's in place. If there is no case law, which is the case on this issue, then they have to go to other less persuasive kinds of authorities. So they're looking to the federal government for appeals that came before the federal government on charges that the federal government was prosecuting for under the death penalty statutes. And probably the last and most persuasive is what people have done in other states. So the judge had to go back and look at federal cases, which are somewhat persuasive, and then was able to pull out a couple of state level cases where other states had dealt with the same issue. Whether or not the Supreme Court is going to find his reasoning solid and say, no, we're not going to allow an interlocutory appeal remains to be seen. So this is very common, especially in death penalty cases, and this up until yesterday was one, to have a lot of these machinations, a lot of legal kind of posturing and a lot of legal positioning. And so it's not uncommon for that to be happening. And it's not uncommon for us to be sort of on pins and needles until jury selection actually starts. So while I don't think that they're going to be able to pull off a last minute interlocutory appeal, it is possible. And it is possible that the Supreme Court could stay the case while they deliberate. So I think we're ready to take some questions. And it's really interesting. I get comments from people who have recently joined us. Now, we got a lot of new subscribers after I was on Surviving the Survivor. Thank you, Joel. And we got a lot of new subscribers. If you're new, I'm super glad you're here. Please subscribe. Please hit the like button. But the subscription is super important. Hit that notification bell, because once the trial starts, I'm going to be trying to post as often as I can from the courthouse, probably twice a day, sort of YouTube short kind of material. Please, if you want to get those notifications, be sure and subscribe and hit the notification bell. And thanks for joining us. So we're ready to take some questions. I'm going to do a little rearrange on my screen because I had a couple things up that I was referring to, and I'd really like to get rid of them so that I can see everybody in full screen. So let me just take care of that for a minute. There we go. It's much easier for me to read the questions when I have full screen on. Julie, supervised custody is special status, like protective custody, administrative segregation, usually could be a mental health watch. No, I'm pretty sure that Vine notification was because she's been transferred to Ada County. She was in supervised custody while she was being transported, because we have that picture of a viewer who saw them on the road today. And at a gas station a couple of hours outside of Boise. So I think we're pretty confident that she's on the move. It's not unusual for them to move an inmate a week or so ahead of a trial, just because they need to get settled into the local jail. They need to figure out the local jail's processes, and they probably need time to also meet with their lawyers, who are undoubtedly have already come to town. So it's not unusual, and I think we can be pretty confident that she's here. So hi, Mary. Question: where does Lori stay when she arrives in Boise? She will be housed in the women's facility of the Ada County Jail. The Ada County Jail here in Boise, and she will be transported daily to the courthouse for her trial. She will be in civilian clothes, but she will have hidden restraints on, and she will be able to have access to reasonable cosmetics and some civilian clothes, and so that's where she'll be. We understand, when I attended the media, the Zoom call for the court that the court put on for the media, one of the questions was whether or not the media would be able to catch shots of her coming and going from the courthouse, and the answer was no. Generally, now I have not really been down to Ada County to I've been there, but I haven't been there to sort of check out the back of the building. But in general, what happens is, in larger courthouses, they have what's called a sally port. And what happens is, inmates who are showing up for trial are in a van. The van, a big roll-up door pulls up like a auto garage. They pull into the sally port. The big roll-up door then pulls down, and the room is secured before the inmates are allowed to leave the van. They're then usually restrained in handcuffs and belly chains to move to the courtroom. Most courtrooms have an inmate holding cell, and the person is put into the holding cell. That would be the point that somewhere in there, either in the holding cell or just before she enters the courtroom, the restraints would be removed, and she would be able to come into the courtroom not looking like she's an inmate. That is an issue that we know that human nature, and particularly on juries, suggests that if somebody comes into court in prison garb and in belly chains, people are going to jump to the conclusion that they're in custody for a reason and they could be guilty. So she is allowed to, anytime she is appearing where the jury might see her, she's in civilian clothes and without visible restraints. Now, there are generally, they wear restraints, but they're not visible they're worn under their clothes. So I have heard that she's in for a little bit of a rude awakening because Madison County Jail is very small and the women's facility is also very small. And so she has enjoyed some, maybe some creature comforts and some decent food. And I don't know, but I have been told that the conditions are vastly better in Madison County than they are in Ada County. And Ada County tends to be more like a big city jail. So I have been told that it's not the most pleasant place. And so what will happen if she is convicted, she will be sentenced and she will leave Ada County and go directly to the Department of Corrections. Now, we do not know what the state and the perhaps the defense attorneys, what sort of provisions they have made for the Arizona charges, when she would go to Arizona to answer those charges. It may be that before she goes into DOC custody here in Idaho, they transport her to answer the charges having to do with Charles's death. We don't know. I think we'll find more out shortly. So I want to interject. Mary Howard, I know I saw your name in the chat. I sent you a little thank you note and it came back that the address was wrong. So I really would appreciate it because I'd like to get this to you. If you would drop your address in my direct messages, either Twitter or Facebook direct messages. And because I want to make sure I have your address so I can get this thank you note to you. So much for the Ada County Jail. What's next? Hi, Diane. Was there a ruling on whether Judge Boyce will allow the recent discovery for Lori's trial? What the judge said at the hearing yesterday morning was that there were several motions that were before the court. There was a motion to compel, a motion to dismiss the death penalty, and a motion in limine. For the uninitiated, motions in limine, it's one of those Latin phrases that hang around in legal talk and make us sound way smarter than we are. But a motion in limine is essentially a pretrial evidentiary motion. So you're asking the court, Judge, before we get to trial, I want a ruling on whether or not this evidence is admissible because I want to keep it out. So the defense filed this motion in limine as part of the motions that they filed having to do with this late DNA. Once the judge said, yes, the late DNA was late, and therefore I'm going to take the death penalty off the table as a punishment or a remedy for that. He also said, I'm going to review that motion in limine, and I am going to issue a written motion in limine that will have to do with all that recent discovery. So we haven't seen that order yet, but he was clear that he felt it was important not to produce an oral order the way he did for the other motions on yesterday. He thought it was important to have that in writing so that everybody knew what the boundaries were going to be, what could be admitted and what couldn't. So it's clear that he is going to keep out all of that recent discovery. But what the four corners of that are going to look like, we don't know yet. So He said he was going to try and get that motion in limine completed and filed sometime this week. So I think we're going to see it soon. So I am just seeing some names in the chat. That Lisa Galindo, what a generous donation. I want to remind everybody, for those of you who are new, all of your donations, your super chats, your donations through PayPal, all go directly to our moderators. And I am absolutely thrilled that I get to write them a check every month. So I appreciate so much that you all appreciate what they do. I want to say that that both of our moderators find your donations so helpful and so affirming for them, and I appreciate being able to be the bearer of the good news and be able to share that with them. Now, I think it's super important to be totally transparent about where your money goes. So YouTube does pay our channel a small amount for the ads. So if you watch a replay and see ads, we make a little bit of money off that. It's not a lot, but it's enough to buy a new ring light or a new microphone, or, to sort of keep the channel going, pay the internet bill. And I am absolutely satisfied with that. This channel was never created with an intention of being a moneymaker for me. It was intended to continue to build a platform and a community for my book, because I'm hoping my book is going to be wildly successful. And so I appreciate every time all of you do something as generous as Lisa. And I'm gobsmacked. I recently went to the PO box and got the latest wristband requests, and someone very sweetly sent me a Starbucks card. Everybody knows I'm a coffeeholic, so it was really sweet of them to do that, and I appreciate it. But I don't need it, and I'm not soliciting those kind of gifts. It's always a very sweet gesture, but I have tried to direct the bulk of what you donate directly to our mods. Somebody asked me to sign up for Buy Me a Coffee, and I guarantee you that I have coffee that will get me all the way through to the trial, and I appreciate that. I do use that and go get a coffee. So, and I thank you for that. Lisa, I just want to point out, we've had some really generous donations. I haven't had the chance to thank everybody, but we do appreciate it. And I can't tell you how much it helps out a couple of our mods. Kathleen Smith, you are so darn faithful, and we appreciate you so much. If Lori's case is appealed, as it probably will be if she's found guilty, could she refuse to testify in Chad's trial to protect her Fifth Amendment rights in case her case is overturned? Before I answer this question, I want to say, when I had lunch today with Jane, she pointed out to me how savvy and educated you all are about this case and about the legal process that happens when I'm going to tip that down so that I'm not cut off by the question. And the legal process that happens, you all are really educating yourself about that, and it's super fun to watch. So this is a good example of that kind of question. So if Lori's case is appealed, the court will issue an order staying any further proceedings. And so, yes, she would be able to exert her Fifth Amendment rights, because she potentially could face another trial. If her trial gets vacated and the appeals court says, we're vacating the verdict in her trial and ordering her to have a new trial, then she'd be right back to where she is now. So yes, I think her lawyers will certainly continue to assert her Fifth Amendment right and say she cannot be, she can't be called because of the potential of her getting a new trial. So, and that's a great, excuse me, a great, super educated question. That is a great, thoughtful question. And every week I see comments from folks saying, not only are your viewers really nice folks, but they're also smart and they ask really good questions. And that makes our conversations so fun for me and helpful and valuable. So thanks for that. I really am genuinely grateful that all of you take the time to spend time with me. I really am. I'm a little humbled. I've never been in a position before where people say, "Oh my gosh, I'm starstruck because I'm going to have lunch with you," and it feels a little weird. But we're all friends, so I can share that with you. So I appreciate that you all join me. It has been so much fun and so rewarding to do this YouTube. It was absolutely terrifying trying to figure out the technology, trying to figure out how to make it work. I appreciate the grace and the patience you've all had with me as we've worked through those things. And it has been genuinely a pleasure for me to do these shows. I'm going to miss doing them while the trial is on, but I will be posting as often as I can for outside the trial. I'll be posting on Twitter in the trial. And we're going to do a 2-hour recap on Saturdays to bring everybody up to speed on what happened in the prior week's trial work. So I'm excited that we're going to be able to do that. I'm super grateful. One of my mods is going to manage all of the social media stuff and take that off me. So I'm super grateful for that. And now we're going to get to this to the next question. Because I want to get to as many as possible. Please know that we can't always answer all of them, but I do every time we do a live. The next day, I sit down with my coffee and I go through the chat and all of the comments that you leave down below. And I answer questions there. I answer questions in my email as well. I feel like part of the reason that we are a good community is because we're all accessible and we have conversations. And so that means that I need to respond when y'all ask. So those who've gotten their questions answered can attest to the fact that I try really hard. I know it's going to be harder once the trial starts, but I'm going to do my best. Debbie Hersko. Debbie, you're amazing, first of all. It's always great to hear from you. And it's always great to hear from your sister. If the jury recommends life without parole, can Boyce give a lighter sentence? You know, I don't believe so because this was initially a death penalty case. And I think there is I think it's a mandatory sentence at this point. But that is a question that I'm going to have to do a little more research on Idaho's sentencing structure. Sentencing since the 80s, when we were talking earlier about this, the pendulum kind of swung toward the tough on crime side of things. One of the things that happened was there were just about every state adopted some sort of mandatory sentencing scheme. And they're very complicated. I used to carry around a colored chart. I should post a picture of it. It looked like the old multiplication tables that you used to have in your peachy on steroids. It was colored and coded, and people used to take, the bar used to offer full seminars, day-long seminars on how to interpret the sentencing rules. So it's a really complex area of the law. I'm not that familiar with Idaho's sentencing structure. I've looked into it. I've read some of it, but That is a question that I think I'm going to have to do some more research on. So what I can tell you is I will do some research on it. And if it seems like it's something that's going to be a little complex, I'll post it in the newsletter. I've got a couple of questions that I'm going to dive into for tomorrow's newsletter. But if that turns out to be one of those, let's get in the weeds, I'll post it in the newsletter. So thanks for asking that, Debbie. Trisha the trucker is in Nashville tonight. Hey, Trisha, it's always so good to hear from you. And I'm always thrilled when you tell me where you are. I'm sort of living vicariously through you. This is a really interesting question. Hello from Nashville. What are your thoughts on the Aidan Fauci sentencing in regard to his age? Aidan Fauci was 14 when he committed this heinous murder. I mean, this, in terms of the brutality and the graphicness of this murder, if I went into it too far, I'd be demonetized on and get suspended on YouTube. So I won't go into it. For those of you who have been watching it, he lured a girl into the woods and he brutally murdered her. It is very clear from the evidence. Now, I did not watch the whole all of the stuff leading up to it, but I did catch the sentencing, part of the sentencing hearing this morning. I admit that I sort of fast forwarded through a few of the victim impact statements so that I could do my homework and be ready for you all. I think this is a really thorny issue. And those of you who've been with me for a while know that a lot of the last few years of my practice were juvenile work, and that I represented some juveniles in some very, very serious charges. So I think the U.S. Supreme Court came out with a ruling, and right now I cannot pull the name of it off the top of my head, but it was a ruling that really changed about 5 or 7 years ago, changed how we look at youth offenders, because the U.S. Supreme Court did come out and say youth offenders are different. You cannot treat them fully as adults. The Supreme Court has said that they believe that the death penalty for youth offenders is cruel and unusual punishment. So the death penalty is never on the table for youth offenders, but there is a provision in most states to remand a juvenile to adult court. Juvenile court is usually has a slightly different jurisdictional basis, and juvenile court generally is a lot of juvenile records are sealed. Some juvenile proceedings are sealed. It's a much less public process. But when the prosecutor decides that they're going to prosecute a youth at this age as an adult, then things change pretty radically. Now, the U.S. Supreme Court has said that we have to take into account a youth's age in determining culpability and sentencing. My recollection is that Aidan Fauci pled guilty. So there's not an issue of his guilt, but there is an issue of what the appropriate sentence would be. I think his attorney would like very much, most states have some sort of provision for the court to review a youth sentence at a certain point, depending on the severity of the crime. In Aidan's case, I think that case is in Florida, if I'm remembering right. There is a provision that case can be reviewed in 25 years. The sentence can be reviewed in 25 years. That's a long time for a person to be in jail. However, it's not a lifetime when you commit the crime at 14. So I I think it's difficult because this case is really an outlier. If you listen to the psychologist talking about the fact that young people at this age, you're looking at less than 1% of youth who are in trouble are violent murderers, violent offenders, predatory offenders. And it's very clear from the facts of the case that he was predatory. So that's a really thorny issue because you have to balance public safety and community safety, along with trying to take into consideration that he's a young kid. Psychologists tell us, and brain scientists tell us that the human brain isn't fully developed until somewhere around age 21, and much later in boys. So we have to take that into consideration when considering the sentence. On the other hand, it is a really heinous crime. And it's clear that it was done in a way that was very predatory. I actually didn't hear the final sentence when I finished the video. The judge had adjourned, and I think there was additional court proceeding today that I haven't gotten to yet. But it would not. I will be unsurprised that the sentence is life. I think his attorney was hoping that there would be a sentence that would take into consideration his youth and maybe allow for parole earlier. In a non-murder case, a lot of times youth are allowed what's called a second look. When I was practicing, it was what we asked for. And there were certain parameters under which a youth had to be had to fall under. And they had to have been model inmates during their detention. And then the court could allow them an early release on their sentence. It usually was done at the halfway point. So I think that's probably what his attorney was trying to do, was to say, we understand that this young man is going to go away. We're just asking the court for the opportunity to take another look at this when he is older, his brain is more developed, and we really can see where his cognitive and emotional abilities shake out. I think it's a really thorny issue. We have all this science that says these kids' brains aren't done. And then we have this young man who clearly thought through, thought out, planned, and preyed on another human being. So I think that's a tough thing to balance. And I certainly think that he is a danger to the community, and he should not be in the community in any way. So juvenile issues and the issue of treating juveniles as adults is something that has always been of interest to me, and may very well be something that you might see from me in the future. So in book form. So let's take a couple more questions and then we'll say goodnight. Remember, we're not going to have a TGIF on Friday because I'm going to be spending a few days with my daughter doing last minute wedding stuff for May. And Maureen, this is a great suggestion, and I guarantee you we will be doing that. My social media person is getting everything set up. She and I are going to meet next week, and we're going to get all that set up so that she can post pictures of the pizza party. She can post pictures on Facebook and Instagram. She can post short video stories, and because I would love for you all to be there. So if you can't be there in person, look for the posts, because you can be there with us in spirit, and you can see the fun later. I'm excited. I'm hoping very much that we're going to have some special guests and have a lot of great fun. So, and thank you, Maureen, for your donation. She will. I'm really looking forward to following Lori Valo Daybell's trial with you at Lori Hellis. You're sharing your legal mind and expertise, and your truly hospitable nature is going to shine beautifully. Well, thank you so much. I enjoy doing this, and I guess it shows. And as I told Jane today when we had lunch, I know I'm an acquired taste, but for those of you who are headed down these rabbit holes with me, I'm grateful that you're along for the ride. So thanks so much for your kind words. Hi, Laura, who is actually digging into the response to the motion in limine. State's response showed tons of it was duplicative and previously sent. So it is going to be the responsibility of Judge Boyce to compare the motions to compel and the discovery production notices and see where they line up. I am certain that he will be asking for some advice from the defense and the prosecution. Where I think he is going, and what I would expect, is he is going to allow in the discovery that came in. He sort of telegraphed that in yesterday's hearing. Everything that came in prior to the 27th will be allowed because it was provided in a timely way. The information that was provided on the 27th, when the prosecution sort of misinterpreted the judge's order, when the judge said everything has to be done prior to the 27th, and they filed at 4:30 on the 27th, admittedly, that was late. But the judge said he felt that there was sort of a reasonable reason why they misinterpreted. There were several hearings. They moved a couple of dates, and he sort of gave them the benefit of the doubt on that. But the 3,000 jail phone calls that came in that were not produced until well after that 27th deadline, they were produced the next week, I'm certain will be off the table and will not be allowed in. And that's what I would expect his order to say based on what he said yesterday in the trial or in the hearing. So I will tell, and anybody who has looked at the FOIA information that came from Arizona, discovery can be really duplicative because what happens is you have reports that come from, let's say, Gilbert Police, and that Gilbert Police report gets included in information that gets sent to the Arizona State Police, and then they file a supplemental report, and then maybe it goes to the FBI, and the FBI has a supplemental report. Well, every time that agency does anything with that initial report from Gilbert, they include copies of all of the previous stuff. So sometimes you will get pages and pages and pages of duplicate and then one thing, and then pages and pages of duplicates and then one thing. And it is an onerous task to weed all that stuff out. The prosecution is not obliged to do that. The prosecution is only obliged to take in the discovery from each agency, mark it and stamp it with their Bates stamps so that it is sequential pages and can be accounted for, and provide it to the defense. It's up to the defense to go through and weed out what's duplicates. And that's a big job in itself. So generally there is an administrative person. If you have a death penalty case and you have a death penalty team, you have an admin assistant whose job is to manage the discovery. You have a couple of attorneys, you have an investigator, a mitigation specialist, and you may have a mitigation investigator who helps the mitigation specialist. So I would expect that in Lori's case, at least, because she has the resources of the state, that the defense has been through as much of that discovery as they can and weeded out all that duplicate stuff. But in the case of the FBI interviews, which they were complaining about. And I want to point out that John Pryor was asking for these FBI interviews last year. This is not new information. What happened was the FBI interviewed a whole bunch of people, and those reports were, and the recordings, I believe, were provided to the defense. But the defense found out, because their investigator was out talking to people, and discovered that a lot of people had been re-interviewed by the FBI. And those re-interviews had never been provided. And when they were requested, the prosecutor just said, well, we'll get them to you when we get them. And the prosecutor didn't take any action to actually go out and proactively obtain those additional reports. So the DA was saying, well, they're duplicates because we sent you all of the interviews. And Jim Archibald stood up and said, that's just not true, because we requested months ago that we get these additional follow-up interviews, and we still haven't seen them. And they showed up a week before the discovery deadline with thumb drives and said, oh yeah, by the way, here's all those FBI interviews. So, even at the point that they were technically in compliance with the discovery deadline, there was a bit of sandbagging going on. And I hesitate to suggest that that was intentional, but there may have been an element of that. Maybe just, we're not going to worry about that. They'll get it when they get it. Not maybe so intentional, but just, I'm too busy. They'll get it when they get it. And that's not the way to manage a death penalty case. So I think the motion in limine is going to keep out all of the stuff that came in after February 27th. The judge sort of telegraphed that he was going to give the prosecution a little bit of grace for the stuff that came in on the 27th, which sort of makes sense since they really got stung when the judge dismissed the death penalty. So let's take one more, and then we're going to say goodnight. Hi, T-Diva. Absolutely, Chad should be indigent by now. We do not have any idea what his agreement is with John Pryor. Whether John Pryor is continuing pro bono, which is possible, whether there is somebody behind the scenes who is helping come up with the money for the experts that they need, whether John Pryor has been able to convince the state to partially fund the investigative piece. We don't know. There are provisions in the Idaho law that allow a privately retained attorney to request investigative assistance from the state in a death penalty case. So I expect that may be where the expert money is coming from, but the truth is we don't know. We know that he signed his house over to John Pryor, gave him the deed to the house. That was, from all indications, somewhere around $80,000 worth of equity in his home. And I guarantee that was eaten up long ago in fees and expenses. So the answer is we don't know. He's clearly indigent at this point. If he were to, there's usually a legal presumption that if you are in custody, you're indigent because you can't go out and get a job or work in your job. So it's clear at this point he's indigent, but he has not requested a court-appointed attorney. I really thought he was going to, back in November timeframe when John Pryor was filing motions saying, I can't be ready. I really thought that was sort of teeing up a request for a court-appointed attorney, but it didn't happen. So I don't know. It's a mystery to everyone where his representation and his support's coming from. I want to thank everybody for spending your Wednesday night with me. It's always a pleasure. I love doing this, and I love all of you. And so once again, I'm going to post this in the community chat so everyone will know. But the schedule is no TJF on Friday. On Monday, I'm going to be appearing back on Surviving the Survivor with Gigi, and the producer from the Netflix series Sins of Our Mothers. And so I'm excited that I'm going to get to have some conversations with those folks. We'll post links so you'll know, and you can tune into that. And then next week, we'll be back on a regular schedule, Wednesday, Friday, and then the trial starts. So I'm looking forward to seeing you all then. Thank you so much to my moderators who are willing to go live at unscheduled times when new things develop. And thank you so much for all joining me. Thanks for supporting our moderators. It means the world to me. And I will see you on Surviving the Survivor on Monday, and then True Crime Wednesday next Wednesday. So stick with us. And if you don't follow me on Twitter, because we're going to be tweeting an awful lot about things that are going on in the case. So I'm going to wish you all a good night.